Thank you so much, Rabbi Rapport, for having me. I'm such a proud member of CBST and honored to be here for Repro Shabbat. To further center myself, I'll just say I'm a white, Jewish, queer, lesbian, cisgender woman. And as you've heard with my wife, Sarah Krulwich, and the mother of twins who are now 29, and exceedingly proud that a picture of our family graces one of the walls at CBST's all-gender bathrooms. At NAPW, we work to make sure that no one is deprived of their civil or human rights because of pregnancy or any outcome of pregnancy. And in recognition and celebration of the fact that trans men and non-binary folk can and do get pregnant, I will be using the terms pregnant people, people with the capacity for pregnancy, as well as pregnant women. So this Repro Shabbat is happening at a very precarious time, not only for reproductive justice, but for our democracy as a whole. For nearly 50 years, activists have been working to reverse Roe v. Wade, the 1973 decision that held that abortion is a fundamental right, and declaring that state laws prohibiting, banning it, overregulating it were unconstitutional. Unfortunately, most of us expect that in June, in the case of Dobbs v. Jackson Women's Health Organization, that's Jackson, Mississippi, the court will drastically limit or fully overturn Roe v. Wade, and not only end legal abortion in the United States, but also disenfranchise half the electorate. And before I get to explaining more of that, there's some things about Roe v. Wade, which is the right decision, the right issue to be talking about in connection with this week's Torah portion, which I will also get to. So some of the things you may and may not know is Roe v. Wade is Jane Roe, the pseudonym given to a woman named Norma McCorvey, who was the lead plaintiff in the challenge to Texas's abortion ban. What you may not know is that she identified herself as a lesbian in her 1994 autobiography, and she was described as being active on the Dallas gay and lesbian scene. Most of you also don't know, even the people who go to law school and read Roe v. Wade, that there was other people who wanted to challenge the Texas law, and among those folks were John and Mary Doe. But in order to bring a case before a federal court, you have to have something called standing. And that's so just because you're unhappy about something, you don't get to go to court. It is the idea that you have to have a direct injury, a direct impact on yourself in order to challenge something the government is doing or failing to do. This couple, a married heterosexual couple called John and Mary Doe, believed that they did have standing because the lack of legal abortion violated their right to what they called in their briefs, very politely, marital happiness. Jane Roe had standing because she was pregnant and the law prevented her having an abortion. But the Does felt that they were injured too. Mary Doe had health problems. If she got pregnant, she might not survive. For various health reasons, she couldn't use the early birth control pills that were very high in estrogen. And they felt that Roe v. Wade interfered very much with their day-to-day lives and their marriage. But I want to tell you how the court saw this and why it's important to me. As described by the court, their claim is that sometime in the future, Mrs. Doe might become pregnant because of possible failure of contraceptive measures. And at that time in the future, she might want an abortion that might then be illegal under the Texas statute. In the end, the court decided they did not have standing and they didn't have a right to be part of the lawsuit, finding that their claim was of harm from the law was way too hypothetical. The court explained the very phrasing of the Doe's position reveals its speculative nature. Their alleged injury rests on possible future contraceptive failure, possible future pregnancy, possible future unpreparedness for parenthood, and possible future impairment of health. Any one or more of these several possibilities may not take place and all may not combine. Now, I should have explained that the first time I read Roe and the impression it made on me was when I was a law student. 1979 probably, at a point in my life where I'd been a feminist for a long time, but I was really just figuring out that I was gay. And I was pretty petrified about coming out to my liberal Jewish parents who turned out to be extremely homophobic, and was just really trying to find my way and to figure out what was safe and what wasn't. We were a long way off from Supreme Court or any court recognition of equal rights for LGBTQI people, including myself at the time. And the court, though, in this case, they're talking about this heterosexual couple. They say, the court also said, in the Doe's estimation, these possibilities might have some real or imagined impact, again, on the politely phrased marital happiness. But the court said, we are not prepared to say that the bare allegation of so indirect an injury is sufficient to present an actual case or controversy. And they were dismissed from the case. They had only an alleged detrimental effect on their marital happiness. So for me, that part of the decision that nobody remembers as a gay person, it was extremely validating and reassuring in a sort of perverse way. It was clear from the decision that in 1973, the Supreme Court had not yet accepted heterosexuality, because what they defined as the experience of any sexually active heterosexual person who can get pregnant, being the fear that you are going to get pregnant, drastically influencing all aspects of your life. But Roe did, while they threw that couple out and reminded me that, you know, they may not have accepted gay rights, but they hadn't accepted heterosexuality either, they did do something extraordinary. They recognized a fundamental right to abortion. But they also did something much, much bigger than that. And what they did is completely consistent with this week's Parshat Mishpatim. They refused to recognize the unborn fetuses at any stage of development as full constitutional persons. The Parshat Mishpatim is about what happens if, in the context of a fight between two men, one of them accidentally pushes a pregnant woman and causes her to have a miscarriage. What's the consequence of that? And the consequence is not to treat what has happened as murder, but rather as something that can be resolved with a fine. In other words, the loss of unborn life, fertilized eggs, embryos, and fetuses is a profound loss, but not the same as killing a person. Roe v. Wade didn't just say abortion is legal, Texas abortion law is wrong. It rejected the argument that fetuses were constitutional persons at any stage of development. The 14th Amendment actually says, in its plain language, that it extends the protection of our Constitution to all citizens, including those who had been recently released from the bondage of American slavery of Black people, and it applied to all persons born. So the Supreme Court said, not fetuses, persons who are born. And by doing that, they did something that had never been done before in US history. They were at the same time necessarily, for the first time, recognizing the full personhood of women and the people of the capacity for pregnancy. It was not until 1972 that the Supreme Court ever said that the 14th Amendment even applied for the concept of basic sex discrimination. The 14th Amendment, in a case that Ruth Bader Ginsburg brought, the court finally said in Reed v. Reed in 1972 that it prohibited discrimination on the basis of sex, that if you had two equally qualified people, one being a woman and one being a man, the state couldn't say the man always got the job. What the court didn't resolve in 1972, a case that wasn't even decided at the time that Roe v. Wade was briefed or argued, was, well, are women equal? Are people who are pregnant also protected by the 14th Amendment, by the Constitution in any way, shape, or form? Well, the court's decision really said that at all stages of pregnancy, the people who get pregnant, women are full constitutional persons. And even though the court said states after fetal viability have the power to regulate one procedure, abortion, after the fetus is viable, even then the court said states must allow women to have abortions if their life and health are at risk, making very clear that while fetuses are not persons, pregnant women are. Now, contrary to this week's portion, we now live in a country where 39 states have feticide or fetal murder laws. Those laws say the opposite of what the Torah portion says. Usually in the wake of extreme violence against a pregnant woman in which she's very severely injured or dies, and there's also a loss of fetal life, anti-abortion activists have rushed in and gotten laws passed that say, look, we want to punish not only the loss of the pregnant woman's life, but also acknowledge the loss of fetal life. And by the way, if you support this law, it will help reduce violence against pregnant women. It will protect pregnant women and their future children. Well, through the work that I do at National Advocates for Pregnant Women, we've come to understand that you cannot make pregnancy termination a crime, ending a pregnancy murder, without it also being used to deprive the people who get pregnant of their constitutional and human rights. Many of these so-called feticide laws include explicit provisions that say, but we don't mean the people who get pregnant themselves. We only mean if they're attacked by somebody from the outside. But these laws have been used to arrest and prosecute women like Brittany Pula in Oklahoma, Chelsea Becker and Adora Perez in California, Purvi Patel in Indiana, for experiencing miscarriages and stillbirths or giving birth to babies who couldn't survive. They have all been charged with murder or manslaughter or depraved heart homicide, using the theory that the unborn are separate persons, and therefore people who get pregnant can be charged with murder, locked up, and deprived of virtually every constitutional right we know of. What I've also learned is that it's not possible, and this was the genius of that Parshat Mishpatim and of Roe v. Wade, that you can't add the unborn, fertilized eggs, embryos, or fetuses to the community of full recognized persons without subtracting the people who get pregnant. I'll give you some examples. If we add the unborn to the Constitution, as might happen, either directly in the upcoming Dobbs decision from the Supreme Court, or even a greater recognition of the state's right to protect unborn lives, the people who get pregnant can lose their right to life. We know that from the case of Angela Carter, who was forced to undergo cesarean surgery, even though the court knew it could kill her. The argument was the fetus is viable, it has a right to life. We can sacrifice the pregnant woman for the life of the fetus. And in the end, they did perform that surgery, and it killed Angela Carter, and her baby did not survive. Savita Halpanavar in Ireland was allowed to die rather than to be able to get an abortion when she had an ectopic pregnancy. It was her death that led to the repeal of their total ban on abortion. Women will lose the right to liberty in its most concrete sense, not to be locked up, not only for feticide if they happen to lose a pregnancy. And by the way, nobody can guarantee that their pregnancy will go to term or there will be a healthy birth outcome. Pregnancy is, as a biological fact, 15 to 20% of all pregnancies end in miscarriages and stillbirths. Women have been arrested, locked up, not just for losing a pregnancy, but for such crimes as child endangerment. That's risk of harm. You don't even have to cause any harm. Women who've fallen down a flight of stairs, have had HIV, drank alcohol, or used a criminalized drug have all been charged with crimes, many of them locked up, many of them freed because of our work, but not all. And I just want to say there is no criminalized drug, not marijuana, methamphetamine, heroin, cocaine, any of the opioids that cause pregnancy losses. If they did, I'd be shipping them to the women in Texas. Women have also been arrested, like Jenny McCormick, for having or attempting to have an abortion. If fetuses, the unborn, from the moment of fertilization are treated as separate persons, lose the right to bodily integrity and medical decision-making. Aisha Magin, Renat Dre, forced to undergo surgery for the benefit, so-called, of their fetuses, treating their decision not to agree to cesarean surgery as the same because they claimed it risked the life of the fetus. It's really no different than an abortion. So we can strap them down, deprive them of their liberty, deprive them of their medical decision-making. Right to travel. Sarah McKenna moved from California to New York while she was pregnant, and the family court treated that move as tantamount to kidnapping her unborn child, and at first refused to allow her to have jurisdiction in the New York family court system. The right to due process, to have a lawyer in Wisconsin, already has something called the Unborn Child Protection Act. It allows state actors to take women into custody if they believe that their past or current use of alcohol or drugs is habitual and endangering the fetus. And in Wisconsin, the unborn child has a right to counsel at the first hearing, where she could be ordered to jail or a mental hospital or forced treatment program. The unborn child has a right to an attorney, but she does not. And there's the right to religious liberty. The religious liberty that defines our values and our decision-making, that allows, requires in some circumstances Jewish women to have abortions to save their lives. In one of the forced cesarean cases, Aisha Magin articulated her refusal of cesarean surgery, which she didn't believe she needed, that didn't have the medical evidence that her fetus was really at risk. But she articulated her refusal, her right to bodily integrity and medical decision-making in terms of her Muslim faith. A judge was called to an emergency hearing, no semblance of due process, and said that all that stood between her at the fetus and life was, simply put, a scalpel, ignoring her decision-making, her religious faith, and every inch of her skin and muscle and uterine wall, as if they didn't exist at all. When fetuses are treated as if they are separate persons, or the state's interest in them is given greater recognition, it adds power to the state to surveil and control. I might point out that actually what Roe v. Wade refused was the idea not only that fetuses are persons, but they're not persons plus. No child, no human being has the right to make another undergo surgery for their benefit. So in fact, what's being pushed in this country at this moment is the idea that the unborn have more rights than any born person does. It could also result in outlawing IVF. As Melissa Murray, professor at New York University School of Law, recognizes, that Roe v. Wade, it's created, established, and developed a line, a thread of thinking based on privacy, and pregnancy. None of us would be here without it. That has also informed so many other decisions by the Supreme Court. Gay rights, contraception, certain fertility treatments, and even interracial marriage, all are imperiled by the potential decision that is coming down from Roe v. Wade that rejects the Jewish teaching that the unborn, that fetuses, embryos, fertilized eggs are not the same as people who are born. As Jews, we are always vigilant to attacks on our rights. We understand that what we have won may not always stay won, and that we have to keep fighting. And what we're fighting for is so much more than abortion. It is about personhood, the personhood of the people who can get pregnant. And one of the geniuses of the anti-abortion, so-called personhood movement is that it distracts our attention from the real fights for personhood, the real movements for personhood. And one of those is Black Lives Matter. It is feminism. It is the movement for disability rights. And I fear that in the coming months, just as the women in Texas right now no longer have a right to abortion in their state, we are going to have to do much more than ensure that people have access to abortion care. We have to do much more than ensure funding and transportation and information about the medications, misoprostol and mifepristone. Those are drugs that are safe and effective in ending a pregnancy. But we're going to have to be looking for many reasons at the threat to our health, our lives, to the equality of half of the human beings in this country, what we will do together in terms of protest and civil disobedience, and providing a safe haven and sanctuary for the people who have abortions, who need abortions, who are charged with murder for having or helping people do that. I hope we will, as a community, be working together to ensure that we all recognize that the people who are deserving of full rights and protection and advocacy are all of those people who are already born. Thank you, everyone.